I never thought a mailbox would ruin my life. But here I was, staring at a certified letter from the Meadowbrook Heights Homeowners Association, informing me that my property was in violation of community standards, and I owed them $500. The offense: my mailbox was painted navy blue instead of the approved forest green. My name is Xavier Winters, and I had moved into this Phoenix, Arizona suburb 6 months earlier, thinking I had found the perfect place to start fresh after my divorce. The house was a modest 3-bedroom ranch style with a decent backyard, and the neighborhood seemed quiet enough. I worked as a software developer from home, so I valued peace and privacy above most things. The HOA paperwork I had signed during closing was thick, but my real estate agent assured me it was standard stuff about keeping lawns mowed and not painting houses neon pink. Nobody mentioned anything about mailboxes. The letter was signed by Patricia Montgomery, HOA president, and the tone was condescending enough to make my blood pressure spike. It stated that I had 30 days to repaint my mailbox to the approved color or face additional fines of $50 per day. Attached was a copy of the community covenants with a highlighted section about mailbox specifications that I genuinely had no memory of reading. I walked outside to look at my mailbox, really look at it, for probably the first time since I moved in. It was a standard post-mounted mailbox, nothing fancy, painted a nice navy blue that matched my front door. The previous owner must have painted it because I certainly had not touched it. It looked fine to me, better than fine actually. Several neighbors had mailboxes in various shades of green, brown, and even one in red. I stood there in the Arizona heat, sweating through my shirt, and felt the injustice of it all wash over me. That evening, I called my neighbor Tom, a friendly guy in his 60s who had lived in Meadowbrook Heights for over a decade. He laughed when I told him about the fine. "Patricia Montgomery strikes again," he said with a weary sigh. She became HOA president about 8 months ago and has been on a power trip ever since. Last month, she tried to fine the Johnsons for having their garbage cans visible from the street on a non-collection day, even though they were just bringing them back from the curb. The month before that, she went after the Harrises for planting roses instead of the approved desert landscaping. "This is insane," I said, pacing my kitchen. $500 for a mailbox color. Can she even do that? Unfortunately, yes. Well, she thinks she can. Most people just pay the fine or fix whatever she is complaining about because it is not worth the hassle. But between you and me, I think she makes up half these rules as she goes along. I have lived here for 12 years and never heard anything about specific mailbox colors until she took over. I thanked Tom and hung up, feeling both validated and frustrated. I was not the type to just roll over when someone tried to bully me, but I also was not looking for a fight. I had enough stress in my life without adding HOA drama to it. Still, $500 was $500, and the principle of the thing gnawed at me. The next morning, I decided to review my closing documents thoroughly. I spent 3 hours going through every page of the HOA covenants, conditions, and restrictions. The section Patricia had highlighted did indeed mention mailboxes, but the wording was vague at best. It stated that all mailboxes should be maintained in good condition and should conform to neighborhood aesthetics. There was no specific color mentioned, no approved paint swatches, nothing definitive. The phrase forest green did not appear anywhere in the official documents. Armed with this information, I drafted a polite response letter to the HOA, explaining that my mailbox was in good condition and that I could find no specific requirement for forest green paint in the official covenants. I requested that they either withdraw the fine or provide documentation showing where this specific color requirement was officially adopted by the HOA board. I sent it certified mail, feeling somewhat proud of my diplomatic approach. 2 weeks later, I received another letter. This one informed me that my appeal had been denied. The fine remained in effect, and I now had only 16 days to comply. Furthermore, Patricia had attached a document titled Meadowbrook Heights Aesthetic Guidelines Amendment, dated just 3 months earlier, which included a detailed section about mailbox colors. Forest green was listed as the only acceptable color for standard post-mounted mailboxes. I read through the amendment carefully. It had supposedly been approved by the HOA board in a meeting I had never been notified about, despite being a homeowner at the time. The minutes of that meeting were not included, and there was no indication that homeowners had been given notice or an opportunity to vote on these new guidelines. That is when I decided to call a lawyer. I was not usually a litigious person, but something about this entire situation felt wrong. The arbitrary rule enforcement, the retroactive fines, the lack of proper notice, it all reeked of overreach and possibly illegal behavior. I asked around and got a referral for Marcus Chen, an attorney who specialized in HOA disputes. His office was in Scottsdale, about a 20-minute drive from my house. Marcus was younger than I expected, probably in his late 30s, with sharp eyes and an easy confidence that put me at ease immediately. I laid out the entire situation for him, showing him all the correspondence, the original covenants, and the mysterious amendment. He listened carefully, taking notes, and when I finished, he leaned back in his chair with a slight smile. This is actually more common than you would think. HOA boards, especially ones with new leadership, sometimes get overzealous and forget that they are bound by their own governing documents and state law. Arizona has pretty specific requirements about how HOAs can adopt amendments and assess fines. "So you think I have a case?" I asked. "I think you have a very good case. First, amendments to HOA covenants typically require a vote of the membership, not just the board, especially if they create new financial obligations like fines. Second, even if the board could unilaterally adopt aesthetic guidelines, they would need to provide proper notice to all homeowners and allow a reasonable time for compliance before assessing fines. You could not be fined for a violation of a rule that did not exist when you moved in and that you were never properly notified about. Relief flooded through me. So what do? We send them a formal legal response, pointing out the deficiencies in their process and demanding they withdraw the fine. We will also request documentation proving that proper procedures were followed in adopting the amendment. If they refuse, we file a lawsuit. HOA cases like this often settle quickly once they realize they are in the wrong, especially when they face the prospect of paying legal fees. "How much is this going to cost me?" I asked, the practical concern settling in. Marcus quoted me his hourly rate, which made me wince, but then he explained that Arizona law allowed for prevailing parties in HOA disputes to recover attorney fees from the losing party. If we win, which I am very confident we will, the HOA will pay your legal costs. You might be out some money up front, but you should get it all back. I signed a retainer agreement that day, and Marcus got to work immediately. Within a week, he had sent a detailed letter to the HOA board, with copies to all board members individually, outlining the legal deficiencies in their fine assessment and demanding withdrawal of the penalty. He requested documentation of proper notice, proof of membership approval for the amendment, and records of any previous enforcement of the mailbox color rule. The response came not from Patricia Montgomery, but from the HOA's attorney, a guy named Robert Sullivan. His letter was dismissive and condescending, stating that the board had full authority to adopt aesthetic guidelines and that my fine was valid. He did not address any of Marcus's specific questions about notice or procedure, and suggested that I simply pay the fine to avoid further legal costs. "Perfect," Marcus said when he showed me the response. "They are doubling down without providing any actual evidence to support their position. That makes our case even stronger." He filed a lawsuit in Maricopa County Superior Court, naming the Meadowbrook Heights HOA as the defendant. The complaint alleged wrongful fine assessment, violation of HOA procedures, and violation of Arizona HOA statutes regarding proper notice and amendment adoption. We also included a request for attorney fees, costs, and a declaratory judgment that the mailbox color amendment was invalid. The next HOA board meeting was scheduled for the following week, and Marcus suggested I attend to observe and possibly speak during the homeowner comment period. I agreed, curious to see Patricia Montgomery in action and to gauge the board's reaction to the lawsuit. The meeting was held in the community clubhouse, a bland beige building near the neighborhood entrance. About 20 homeowners showed up, which Tom told me was actually a good turnout. Patricia Montgomery sat at the head table with 4 other board members, 2 middle-aged men who looked bored, an elderly woman who seemed confused about why she was there, and a younger woman who kept checking her phone. Patricia was exactly what I expected. She was probably in her early 50s, with an angular face, severely styled blonde hair, and an expression of permanent disapproval. She wore a navy blue pantsuit and had a stack of papers in front of her that she kept referring to with great importance. The meeting started with standard agenda items: approval of previous meeting minutes, financial report, discussion of upcoming community events. Patricia spoke in a clipped, authoritative tone that brooked no disagreement. When the treasurer mentioned that HOA reserves were lower than projected, she cut him off and said they would address it in executive session, which apparently meant without homeowners present. Finally, we reached the homeowner comment period. An older man stood up to complain about kids riding bikes too fast through the streets. Patricia assured him she would send a newsletter reminder about community safety rules. A woman asked about the pool hours being reduced, and Patricia explained that it was due to lifeguard shortages, though her tone suggested the topic was closed for discussion. I stood up, and Patricia's eyes narrowed when she recognized my name. "Xavier Winters," I said clearly. "I am here to address the fine I received for my mailbox color and the lawsuit that has been filed as a result. That matter is currently in litigation and not appropriate for discussion at a board meeting." Patricia interrupted immediately. "Actually, I am not asking for discussion. I am simply informing the community that the board has been assessing fines based on an amendment that may have been improperly adopted and without proper notice to homeowners. I think other residents have a right to know how their HOA is being run." Several homeowners perked up at this, and I saw a few people whispering to each other. Patricia's face flushed red. "The board has full authority to establish and enforce community standards. Your refusal to comply with a simple, reasonable request has forced the HOA to spend money on legal defense that could have been used for community improvements. I suggest you reconsider your frivolous lawsuit before you cost your neighbors even more money." The accusation that I was somehow harming the community by defending myself made my temper flare, but Marcus had coached me to stay calm. I think homeowners should ask themselves whether retroactive fines for mailbox colors are a good use of community resources, but I will let them make that judgment. Thank you for your time. I sat down, and Patricia quickly moved to the next agenda item, but I noticed several people looking at me with curiosity rather than hostility. After the meeting, 3 different homeowners approached me to ask about the situation. 2 of them had received similar petty fines from Patricia for minor violations, and one man, a lawyer himself named George, said he had been considering challenging the board's practices, but had not wanted to deal with the hassle. "If you are taking them on, I hope you win," George said, shaking my hand. "Patricia has been a nightmare for this community. She treats the HOA like her personal fiefdom. Over the next few weeks, the legal process ground forward. The HOA filed a response to our lawsuit, but it was largely a rehash of their attorney's earlier letter, with no substantive evidence addressing our claims. Marcus filed a motion for summary judgment, arguing that the undisputed facts showed the HOA had violated proper procedures and that we should win without needing a trial. The discovery process was enlightening. Through formal legal requests, we obtained copies of board meeting minutes, financial records, and correspondence. What we found was damning. The so-called amendment establishing mailbox color requirements had been adopted in a board meeting with only 3 of 5 board members present, with no notice to homeowners, and without any membership vote. Even more interesting, the HOA's own attorney had sent a memo to Patricia 2 months before my fine, warning her that unilaterally adopting new fine-eligible rules without proper notice could expose the HOA to legal liability. She had apparently ignored that advice. We also discovered that I was not the first person Patricia had targeted. In the 8 months since she became president, she had issued fines to 17 different homeowners for various minor infractions. Most had paid without challenging her because the amounts were relatively small, and people did not want the conflict. But the pattern showed a clear practice of arbitrary and aggressive enforcement. Marcus was gleeful when he reviewed the discovery materials. "This is even better than I thought. Not only did they violate procedure on your fine, but there is a pattern of abuse and evidence that they were warned about exactly what they are being sued for. The judge is going to love this." The hearing on our summary judgment motion was scheduled for a Thursday morning in late spring. Phoenix was already heating up, promising another brutal summer. I wore a suit, feeling overdressed and nervous, even though Marcus assured me that these hearings were mostly legal argument and I probably would not need to say anything. The courtroom was small and stuffy, with harsh fluorescent lighting. The judge was a woman in her 60s named Sandra Reeves, who had a reputation, according to Marcus, for not tolerating nonsense and for being particularly unimpressed with HOA overreach. Robert Sullivan, the HOA's attorney, presented their argument first. He claimed that the board had acted within its authority, that the aesthetic guidelines were a reasonable exercise of their powers, and that I was making a mountain out of a molehill over a simple request to paint a mailbox. He glossed over the procedural issues and focused on the idea that HOA boards need flexibility to maintain community standards. Judge Reeves interrupted him several times to ask pointed questions about notice requirements and the statutory procedures for adopting amendments. Sullivan's answers were evasive and unconvincing, citing vague language about board discretion without addressing the specific statutory requirements Marcus had cited in our briefs. Then, it was Marcus's turn. He was precise and methodical, walking the judge through Arizona HOA statutes, the HOA's own governing documents, and the timeline showing how I had been fined for violating a rule that did not exist when I bought my house, and that I was never properly notified about. He presented the memo from the HOA's own attorney warning about this exact problem, and he showed the pattern of Patricia's aggressive fine enforcement. "Your Honor," Marcus concluded, "this is not about a mailbox. This is about an HOA board that believes it can make up rules as it goes along, impose fines without proper authority, and intimidate homeowners into compliance." Mr. Winters did exactly what he should have done. He stood up for his rights. Arizona law is clear that HOAs must follow proper procedures, and this HOA failed to do so in multiple respects. We respectfully request that the court grant summary judgment in favor of Mr. Winters, invalidate the fine, and award attorney fees and costs. Judge Reeves took a brief recess to review the materials, and when she returned, her expression told me everything I needed to know. "I have reviewed the pleadings, the evidence, and the relevant statutes. It is clear to the court that the defendant HOA failed to follow proper procedures in multiple respects. The amendment establishing specific mailbox color requirements was adopted without proper notice to homeowners and without the required membership vote. The fine assessed against Mr. Winters was therefore invalid. Moreover, the evidence shows a pattern of arbitrary enforcement that raises serious concerns about the HOA's governance." She paused, looking directly at Robert Sullivan. "HOA boards are given substantial authority to manage communities, but that authority is not unlimited. They must follow their own rules and state law. When they fail to do so, homeowners have every right to challenge them in court. This is not a frivolous lawsuit, as the HOA characterized it. This is a homeowner exercising his legal rights in the face of overreach." She granted our motion for summary judgment in full, invalidated the fine, and ordered the HOA to pay my attorney fees and costs. She also ordered the HOA to send notice to all homeowners informing them that the mailbox color amendment had been invalidated and offering to refund any fines that had been paid for mailbox color violations. Walking out of that courtroom felt like floating. Marcus was grinning, shaking my hand and congratulating me on the win. "That was about as decisive as it gets," he said. "Judge Reeves basically eviscerated their entire position. Now we just need to sort out the attorney fees." The fee petition Marcus filed was for $12,000, which included all of his time, paralegal time, filing fees, and costs. It seemed like a lot to me, but he explained that HOA litigation required extensive document review and legal research, and the case had actually been relatively efficient compared to many disputes that dragged on for years. The HOA balked at the fee amount, of course. Robert Sullivan filed an objection claiming the fees were excessive and unreasonable. This led to another hearing where Marcus had to present detailed time records and justify his billing. Judge Reeves reviewed everything and approved the full amount, noting that the fees were entirely reasonable given the work involved, and that the HOA's decision to fight the case, rather than concede early, had driven up the costs. The HOA was ordered to pay me $12,000 within 30 days. I waited, curious whether they would actually pay or try to appeal. At around day 25, a check arrived in my mailbox, my navy blue mailbox from the Meadowbrook Heights HOA in the amount of $12,000. I deposited that check with more satisfaction than any money I had ever received. Not only had I won, not only had I vindicated my rights, but I had not paid a dime out of pocket. The HOA, meaning ultimately the community's funds that could have been used for legitimate purposes, had paid for their president's power trip. The fallout in the neighborhood was immediate and dramatic. Judge Reeves's order requiring notice to all homeowners meant that everyone in Meadowbrook Heights received a letter explaining that the mailbox rule had been invalidated and that the HOA had lost a lawsuit over it. People started asking questions about how the HOA was being run and what other questionable decisions Patricia had made. A group of concerned homeowners, including Tom and George, organized a petition to call a special meeting to recall Patricia Montgomery from the board. Arizona HOA law allowed for such recalls if enough homeowners supported it. They needed signatures from 20% of the homeowners, and they got them in less than 2 weeks. The recall meeting was packed. More than 100 homeowners showed up, filling the clubhouse beyond its comfortable capacity. Patricia tried to maintain control, but the mood was hostile. Homeowner after homeowner stood up to complain about her leadership, her aggressive fine enforcement, her refusal to listen to concerns. Some people were angry about the wasted money on the lawsuit. Others were frustrated by her general attitude and approach to governance. I spoke briefly, keeping it factual and calm. I explained what had happened with my case and how the judge had found the HOA's actions to be improper. I made it clear that my issue was not with the HOA concept itself, but with how it was being run. We all want a well-maintained community, I said, but there is a difference between reasonable standards and arbitrary power. What happened to me could happen to any of you, and I think we deserve better leadership. The vote was not even close. Patricia Montgomery was recalled by a margin of more than 2-1. She left the meeting red-faced and furious, muttering about ungrateful neighbors and lawsuits of her own, though none ever materialized. The other board members, who had largely been passive enablers of her behavior, also resigned rather than face potential recall votes themselves. A new board was elected within a month. George, the lawyer who had supported me, became the new president. Their first act was to review all of Patricia's fines and refund the ones that had been improperly assessed. They also instituted new procedures requiring proper notice and due process before any fines could be issued. The community felt different almost immediately, less tense and more neighborly. As for my mailbox, it stayed navy blue. Nobody bothered me about it, and I noticed a few other neighbors painting their mailboxes different colors, taking advantage of the invalidated rule. It became a small symbol of the neighborhood's liberation from Patricia's regime. Marcus Chen and I stayed in touch. He told me the case had become something of a cautionary tale he shared with other HOA attorneys, an example of what happens when boards overreach and ignore proper procedures. He also said he had received several calls from other homeowners in different communities facing similar issues, all of them referencing my case as inspiration. About 6 months after the lawsuit concluded, I was outside washing my car when Tom came over with a beer for each of us. We sat on my driveway in lawn chairs, enjoying the slightly cooler evening weather. "You know, you did this whole community a favor," Tom said, taking a sip of his beer. "Patricia needed to be stopped, and none of us had the guts to do it. You stood up when it mattered." "I just did not want to pay an unfair fine," I said, though I appreciated his words. "I got lucky that the law was on my side and that I found a good lawyer." "Maybe, but you still had to make the choice to fight. A lot of people would have just paid the $500 and moved on. The fact that you did not, that is what made the difference." We sat there in comfortable silence for a while, watching the sunset paint the Arizona sky in shades of orange and purple. My mailbox stood at the end of my driveway, navy blue and defiant, a small monument to the principle that sometimes you have to stand up against petty tyranny, even when it seems easier not to. The whole experience taught me something valuable about community, governance, and individual rights. HOAs serve a legitimate purpose in maintaining property values and community standards, but they are only as good as the people running them, and only legitimate when they follow proper rules and procedures. When they stop being accountable to the homeowners they serve, they become little dictatorships that need to be challenged. I also learned that the legal system, for all its flaws and expenses, can actually work the way it is supposed to. Arizona's laws protecting homeowners from HOA overreach were clear and effective. Judge Reeves applied them fairly and decisively. Marcus did his job with skill and dedication. The whole process, while stressful, ultimately vindicated the principle that rules matter and that even homeowners associations have to follow them. Life in Meadowbrook Heights settled into a pleasant routine after that. The new board was responsive and reasonable. They maintained community standards without being oppressive about it. They fixed things that needed fixing, like the pool hours and some drainage issues, without wasting money on petty enforcement actions. I even joined the Architectural Review Committee, figuring that if I was going to live in an HOA community, I might as well help make it a good one. We developed clear, fair guidelines for home improvements and modifications, and we made sure everyone knew what the rules were before we ever considered enforcement. It was amazing how much easier everything worked when people were treated with respect and given reasonable notice and opportunity to comply. Patricia Montgomery moved out of Meadowbrook Heights about 8 months after her recall. Rumor had it that she moved to a different community across Phoenix and tried to join that HOA board, but they rejected her application after someone did a background check and found out about the lawsuit and recall. I felt a small satisfaction hearing that, though mostly I just felt relieved she was someone else's problem now, or hopefully nobody's problem if that board had any sense. My navy blue mailbox became something of a landmark in the neighborhood. New residents would sometimes ask about it, and I would tell them the story. It became a reminder, both to me and to others, that standing up for what is right matters, even in small things. Especially in small things, actually, because that is where tyranny usually starts, with small, seemingly insignificant impositions that people tolerate because resisting seems like too much trouble. The $12,000 I received from the HOA went into my savings account. I thought about using it for a vacation or some home improvement project, but ultimately I just held on to it as an emergency fund. Money earned from fighting for principle felt different somehow, more solid and meaningful than money earned from regular work. It represented not just compensation for legal costs, but validation that I had been right to stand my ground. Marcus Chen sent me a nice bottle of scotch when the case finally closed, with a note thanking me for being a client who was willing to see things through to the end. We had dinner a few times over the following year, and he told me about other HOA cases he was working on. Some were similar to mine: wrongful fines, improper procedures, board overreach. Others involved more serious issues like discrimination, financial mismanagement, and even fraud. He said the HOA law area of practice was booming because more and more Americans lived in HOA-governed communities, and more people were willing to challenge unfair treatment. One case he told me about involved an HOA that had been systematically discriminating against families with children, trying to turn a regular neighborhood into an unofficial retirement community. Another involved a board president who had been embezzling HOA funds for years, living a lavish lifestyle while the community's common areas deteriorated. Hearing these stories made me grateful that my situation had been relatively straightforward, and that it had been resolved quickly. I also learned that not all HOA disputes end as well as mine did. Marcus told me about clients who had won their cases, but had been ostracized by their neighbors, making their lives miserable even after legal vindication. Others had faced retaliation from boards in the form of selective enforcement and constant harassment. Some had won their legal battles but lost the war, eventually selling their homes and moving just to escape the conflict. I was fortunate that Meadowbrook Heights had enough reasonable people who recognized that the problem was Patricia, not me. The new board made it clear from the start that there would be no retaliation, and that my willingness to stand up to improper governance had been a service to the community. That message, coming from leadership, made a huge difference in how other residents treated me. As time passed, the whole incident began to feel almost surreal, like something that had happened to someone else. I would see my mailbox every day and sometimes forget why it was significant. It was just my mailbox, the color I liked, on my property. The fact that it had been the source of so much conflict and legal action seemed absurd in retrospect. But then, I would remember Patricia's condescending letters, the casual way she tried to impose her will, the assumption that I would simply comply because resistance was too difficult. I would remember the feeling of injustice when I first received that fine, the frustration of dealing with arbitrary authority, the decision point where I had to choose between giving in or fighting back. Those memories kept the lesson fresh. The experience changed how I thought about homeownership and community governance. Before this happened, I had been fairly apolitical, not particularly engaged with local issues or community decision-making. I voted in major elections, but paid little attention to HOA politics or local government. Now, I understood viscerally how much impact these small-scale governance structures have on daily life, and how important it is to stay informed and engaged. I started attending HOA board meetings regularly, even after the recall drama settled down. I read the meeting minutes and financial reports. I asked questions when things were not clear. I was not trying to be difficult or obstructionist, but I was determined to be an informed homeowner who held the board accountable. And I encouraged my neighbors to do the same. The community benefited from this increased engagement. When more homeowners paid attention, the board was more careful and thoughtful in its decisions. When people asked good questions, problems were identified and addressed before they became crises. The whole system worked better when people participated rather than just trusting that someone else would handle things properly. George, the new HOA president, told me several times that my lawsuit had been a wake-up call not just about Patricia's leadership, but about governance generally. The new board took its responsibilities seriously precisely because they had seen what happened when a board abused its authority. They knew they were being watched, and they knew that homeowners now understood they had rights and options if the board misbehaved. One interesting development was that the HOA's insurance company audited the entire operation after my lawsuit. Apparently, having to pay out on a claim for wrongful fine enforcement triggered a review of the HOA's practices and procedures. The insurance company required the board to implement better controls, including mandatory training for board members on Arizona HOA law, required approval from the HOA attorney before assessing significant fines, and a formal appeals process for homeowners who disagreed with board decisions. These changes would not have happened without the lawsuit. The old board, under Patricia's leadership, would have resisted any constraints on their authority. But the new board welcomed the structure and guidance, recognizing that clear procedures protected both homeowners and board members from misunderstandings and conflicts. The attorney fees provision in Arizona HOA law turned out to be a powerful tool for holding boards accountable. The fact that the losing party pays the winner's legal fees meant that homeowners with legitimate grievances could afford to challenge improper actions, and boards had to think twice before digging in on indefensible positions. If HOAs knew they might have to pay tens of thousands of dollars in legal fees if they lost, they were more careful about following proper procedures in the first place. Marcus explained that this fee-shifting provision existed specifically because HOAs have access to all the community's funds while individual homeowners usually have limited resources. Without fee shifting, HOAs could bully homeowners through expensive litigation even when the homeowner was in the right, knowing that most people could not afford to fight back. The fee shifting leveled the playing field and made the threat of litigation a credible deterrent against HOA overreach. My case became a teaching example in another way too. The local newspaper picked up the story several months after it concluded, running a feature about HOA disputes and homeowner rights. They interviewed me, Marcus George, and even managed to get a brief comment from Robert Sullivan, the HOA's attorney, who declined to discuss the specifics, but acknowledged that HOA boards need to be mindful of proper procedures. The article generated a lot of response. The newspaper received dozens of letters from readers sharing their own HOA horror stories. Some were similar to fines for minor infractions, selective enforcement, hostile board members. Others were worse: discrimination, harassment, financial mismanagement. The article seemed to tap into a deep well of frustration with HOA governance that many people felt, but few were willing to publicly discuss. A few local attorneys who specialized in HOA law, including Marcus, started offering free workshops for homeowners about their rights and how to deal with HOA disputes. I attended one of these workshops as a guest speaker, sharing my experience and encouraging people to stand up for themselves when faced with improper treatment. The room was packed with homeowners, many of them dealing with active disputes with their own HOAs. The questions people asked were revealing. Many felt completely powerless against their HOAs, convinced that the board could do whatever it wanted and that resistance was futile. They were shocked to learn about the procedural requirements, the limitations on HOA authority, and the availability of attorney fee awards for prevailing homeowners. Several people came up to me afterward to thank me for sharing my story, and to say it had given them the courage to challenge improper fines or decisions they had been living with. One woman, probably in her 70s, told me through tears that her HOA had been fining her for having a small vegetable garden in her backyard, claiming it violated aesthetic standards even though it was not visible from the street or any neighbor's property. She had been paying $50 a month for 2 years because she thought she had no choice. After hearing my story and learning about homeowner rights, she said she was going to fight back. I gave her Marcus's card and hoped she would follow through. These interactions reinforced for me that my decision to fight over a mailbox had been about more than just my own situation. It had been about establishing a precedent, demonstrating that HOA overreach could be successfully challenged, and encouraging others to stand up for their rights. If my case helped even a few people avoid unjust fines or empowered them to challenge improper governance, then all the stress and effort had been worthwhile. Life moved forward in other ways too. I started dating someone I met through a friend, a woman named Paula Mitchell who worked as a teacher in Scottsdale. When I told her about the mailbox saga on our third date, She laughed and said it was the most Phoenix story she had ever heard. She lived in an apartment and had never dealt with an HOA, but she appreciated the principle of standing up to bureaucratic nonsense. Paula and I got serious pretty quickly, and about a year after the lawsuit concluded, she moved into my house. She loved the neighborhood, got along great with Tom and the other neighbors, and thought my navy blue mailbox was perfect. She even suggested we plant flowers around the mailbox post to make it stand out more, which we did. It became a small point of pride, that mailbox a symbol of our home and our willingness to be ourselves. When we got engaged a few months later, we joked about having the wedding in front of the mailbox, though we ended up going with a more traditional venue. But we did take some of our engagement photos in the neighborhood, and yes, the mailbox made an appearance. Our photographer thought it was quirky and fun, and the photos turned out great. The Meadowbrook Heights community continued to thrive under its new leadership. Property values in the neighborhood actually increased, partly because word got around that the HOA was reasonable and well managed. Potential buyers liked knowing they would not be hassled over minor infractions, and real estate agents started marketing homes in our community as being in a reformed HOA neighborhood. George served as HOA president for 2 years before stepping down, having established good governance practices and a healthy culture of accountability. His successor was a retired accountant named Dorothy, who was detail-oriented and fair-minded. The transition was smooth, and the community's positive trajectory continued. I eventually rotated off the Architectural Review Committee, having served for about 3 years. I felt good about the work we had done clarifying standards, treating homeowners with respect, maintaining property values without being unreasonable. The committee had become a model for how HOA governance should work, and I was proud to have been part of that transformation. The legal precedent from my case was cited in a few other Arizona HOA disputes. Marcus told me about at least 3 cases where attorneys had referenced Winters v. Meadowbrook Heights HOA in their briefs, using it to support arguments about improper fine assessment or lack of proper notice. Judge Reeves's decision had become part of the body of Arizona HOA law, a small but meaningful contribution to protecting homeowner rights. Looking back on the whole experience, I realized that the $500 fine I refused to pay had led to profound changes in my community, in my own life, and potentially in the lives of other homeowners facing similar situations. It had been stressful and time-consuming, but it had also been empowering and ultimately rewarding. The navy blue mailbox still sits at the end of my driveway, now surrounded by flowers and looking better than ever. Every time I get the mail, I am reminded that standing up for what is right matters, that individuals can challenge unjust authority successfully, and that sometimes the smallest things a mailbox color, a $500 fine, can become catalysts for meaningful change. Patricia Montgomery faded into memory, a cautionary tale about what happens when people let power go to their heads. The Meadowbrook Heights HOA became an example of how community governance should work: transparent, accountable, reasonable, and respectful of homeowner rights. And I learned that being informed, engaged, and willing to stand your ground when necessary are essential qualities not just for dealing with HOAs but for citizenship generally. The $12,000 I received from the lawsuit turned out to be seed money for my life with Paula. We used part of it for our wedding and put the rest toward home improvements that we both wanted. Every time we enjoyed our renovated kitchen or relaxed on our new patio, I thought about how that money represented justice served and principle vindicated. It made those improvements sweeter somehow, knowing they were funded by holding an abusive authority accountable. My neighbor Tom remained a good friend. He told me more than once that watching me take on the HOA had inspired him to be more engaged and assertive in his own life. He started speaking up more at work, advocating for better processes and challenging decisions he thought were wrong. He credited my example with giving him the confidence to do that, which was humbling and gratifying to hear. The whole experience taught me lessons I carried into other areas of life. I became more willing to question authority and challenge unfair treatment, whether in dealing with businesses, government agencies, or other institutions. I developed a healthy skepticism of claims that this is just how things are done, and a determination to verify that rules and procedures were being followed properly before accepting adverse decisions. I also became an advocate for clear communication and transparent governance in every context. At work, I pushed for better documentation of decisions and clearer policies. In volunteer roles, I insisted on proper procedures and fair treatment. In personal relationships, I valued honesty and directness. The HOA experience had shown me how much damage could be done by arbitrary authority and poor communication, and I was determined not to replicate those problems in areas where I had influence. Marcus Chen and I remained friends beyond the attorney-client relationship. We had dinner every few months, and he kept me updated on interesting cases and developments in HOA law. He told me that my case had been personally meaningful to him too, a reminder of why he had gone into law in the first place, to help individuals stand up against more powerful entities, and to use the legal system to achieve justice. Years passed, and life in Meadowbrook Heights remained pleasant and drama-free. The neighborhood aged well, with mature landscaping and well-maintained homes. The HOA continued to function competently and fairly. Property values appreciated. New families moved in, and the community remained vibrant and diverse. Occasionally, a new resident would ask about the legend of the navy blue mailbox, having heard the story from a neighbor or real estate agent. I would tell them what happened, usually in abbreviated form, emphasizing the lessons about proper governance and homeowner rights. Most people found it fascinating and reassuring, glad to know that the HOA could be held accountable and that they lived in a community that valued fairness. The story took on a life of its own over time, becoming part of the neighborhood's history and identity. It was referenced in HOA newsletters, mentioned at board meetings as an example of lessons learned, and shared with new board members as a cautionary tale. In a strange way, Patricia Montgomery's attempt to bully me over a mailbox color had become the defining moment that shaped the community's culture for years to come, just not in the way she had intended. I sometimes wondered what Patricia was doing and whether she had learned anything from the experience. I doubted it, honestly. People like that rarely gained self-awareness or acknowledged their mistakes. More likely, she blamed me and the other homeowners for not appreciating her leadership and convinced herself she had been treated unfairly. But that was her problem, not mine. What mattered was that the Meadowbrook Heights community had learned and grown from the experience. We had better governance, more engaged homeowners, and a culture of accountability and respect. We had proven that communities could self-correct when things went wrong, and that bad leadership did not have to be tolerated indefinitely. My navy blue mailbox became such a fixture that when Paula and I considered repainting it to freshen up the appearance, several neighbors actually asked us not to change the color. It had become part of the neighborhood's character, they said, a symbol of what the community stood for. So we kept it navy blue, touching up the paint but preserving the color that had started everything. As I write this, more than 5 years after the original fine notice arrived, I can honestly say that refusing to pay that $500 was one of the best decisions I ever made. It was not about the money, though getting $12,000 in legal fees paid by the HOA was satisfying. It was about principle, about refusing to accept arbitrary authority, and about standing up for what was right even when it would have been easier to just go along. The experience shaped who I became and how I approached the world. It taught me that change was possible, that individuals could make a difference, and that the legal system could work when used properly. It showed me the importance of community engagement and the value of holding leaders accountable. And it reminded me that sometimes the most important battles are fought over the smallest things, because principles matter regardless of the scale. My navy blue mailbox stands at the end of my driveway, a monument to the idea that homeowners have rights, that HOAs must follow proper procedures, and that standing up to petty tyranny is not just possible but necessary. Every time I check the mail, I am reminded that I fought back and won, that justice prevailed, and that one person willing to stand their ground can change an entire community for the better. The Meadowbrook Heights HOA learned an expensive lesson about proper governance and respect for homeowner rights. Patricia Montgomery learned that power has limits and that accountability matters. And I learned that fighting for what is right, even when it seems like a small thing, can have profound and lasting impact. That mailbox, navy blue and defiant, will always represent those lessons and the satisfaction of knowing I did not just roll over when someone tried to bully me. Life is full of moments where we have to choose between accepting unfair treatment or standing up for ourselves. The HOA mailbox incident was my moment, and I chose to fight. The outcome validated that choice in every way, and I hope my experience inspires others facing similar situations to know their rights, stand their ground, and refuse to be intimidated by arbitrary authority. Sometimes all it takes is one person saying no to change everything, and I am proud to have been that person for my community.